So look, I've noticed the comments made by the person who's the whistleblower in relation to New Zealand, and particularly why I've been quiet about the Cook Islands. So there's a few important things to understand. Prior to 1988, there were issues about New Zealanders avoiding their tax by having a structure in the Cook Islands. In 1988, that all closed down, and subsequent to then there'd been no issues, because that was why we changed the way we tax a trust in New Zealand, or a foreign trust, by using the set law. So that well and truly predates me, has nothing to do with me. Secondly, the whistleblowers got confused about my responsibilities. I have no responsibilities for the tax jurisdiction of the Cook Islands. New Zealand has responsibilities for foreign policy and defence of the Cook Islands, but not for tax. I have as much responsibility for tax in the Cook Islands as I do for tax in Russia. The third point is that New Zealand actually does try and support the Cook Islands in improving its tax and the way it operates its system. It has its own double tax agreements, its own tax information sharing agreements, and over the years post 1988, New Zealand's been working with the Cook Islands to make sure they've got a better structure and that they're operating in a way with much greater transparency. So in so much that New Zealand gets involved at all, it's through our officials basically trying to provide support for them and encouraging them to have best practice. So outside of that, that's why I'm quiet on it, because I don't have any responsibility for it.
Do you draw anything from the motives or the identity of that whistleblower based on that sort of strange decision to pull you out?
Well, look, I've asked the tax officials this morning why would someone make a comment like that, and they said that he or she is likely to be European. The Europeans get terribly confused with the Cook Islands because they use New Zealand dollars. And he said it's a common mistake made by Europeans that they look at the Cook Islands and sometimes make reference to New Zealand, but we have no responsibility for it.
Just on the wider issues, the Australian Financial Review yesterday published, I think it was about a 3,000 word piece on the torrent of money coming into New Zealand last year into foreign trusts, and some of that is quite sort of like questionable. Does that cause you any concern about damage to New Zealand's reputation?
Yeah, okay, so if you look, again, I've had some discussion with the IRD officials. They say they've looked at all of the international media in relation to the Panama Papers, and on a basis, if you look at the international media, New Zealand is barely ranked as a footnote. So the concerns have been around the United Kingdom, the United States, and quite a number of other countries who make up the top 10. New Zealand doesn't rate in that sort of information. I mean, what is true is that every country around the world has a slightly different tax system. And so whether it's a multinational potentially looking to get the best tax position, or a foreign trust, or a look-through company, or various other things, there is potentially the mismatch between those systems to look to deal with that information. So New Zealand's unique in so much that its tax rules are a bit unique to New Zealand, but that's like saying Australia is unique or the UK is unique. They're all a little bit different. But what New Zealand is doing is it's working with the OECD and all of the other countries to look at those mismatches, to see whether there's the potential for us to close those things down, because we want to close those down because we want multinationals paying what we think is their fair share of tax, and we think in some cases they are potentially not. Not that what they're doing is unlawful, but because of this mismatch they have that capacity. But we can't do that on our own. We have to do that with all the other things. So in relation to the Mexican individual that's a question, where the story was based on this guy, IRD have had a look at as best they can. Again, that particular case, what they say is that the person set up a foreign trust in New Zealand. The trust actually bought an entity in the United Kingdom. No one internationally has said that those funds are illegal. I don't have any basis of knowledge of them, but no one said that they're illegal. So there are questions about him and his relationship with the Mexican president. That's something for others to look at. So then you've got to have a look at, overall in terms of what we are doing. So we have been looking both at strengthening our disclosure rules. So again, we're in the process, actually predating the Panama Papers, moving towards more automatic and fuller disclosure and with other jurisdictions outside of Australia, because we already do that with Australia. We've got John Shewan undertaking a review, and again, if there are better parts to the disclosure regime that we can improve, again, we'll go and look at that. In terms of the overall tax treatment, again, we don't want to change tax in the set law, but we will look and see with the OECD and others if there's more we can do. And finally, in relation to the release of the information, IRD say that they've seen this kind of information before. It's very complicated, but what they will do is set up a small team to look at the individual cases that, if any are identified, they'll go through, and if people haven't paid their fair share of tax and they've unlawfully avoided paying tax in New Zealand, then they'll be subject to the full front of the law like anybody else that undertakes tax evasion. So we'll go and have a look. If there's some learnings, will come out of it. If someone hasn't done the right thing, then they should expect a knock on the door from IRD. But outside of that, that's all we can say.
But isn't the major concern about the individuals setting up trusts in New Zealand, where they're not required to pay tax, so they're not breaking any laws here, but it's just perhaps some of the sort of allegations surrounding their character, if you like?
Yeah, okay, so if you use a trust firm and a top tier firm, then you're subject to the anti-money laundering rules, part 1, that have been passed by our government. And those rules require you to understand both the nature of the individual and the source of the money. So in fact, actually, if you look at my previous lawyer, Ken Whitney, he's no longer a lawyer, but we're getting complicated, but if you look at him, his firm is exactly like that. They're covered under part 1 of the anti-money laundering rules. They have to know their client, they have to know where the source of income has come from. We're in the process of looking to pass part 2 of that, which would broaden out more to people who aren't specialists in trusts, but that work does need to be resolved. I mean, it's worth remembering, though, that there's been a number of reviews about New Zealand's disclosure regime, its double tax agreements, its information sharing agreements, and we have always been ranked in the highest category. So no one has raised issues that New Zealand has been anything other than a full and high level of disclosure. We just have a different way of taxing the set law compared to some other countries, and that was because of what happened in pre-1988, where people could actually register a trust offshore and not pay their rightful amount of tax. So what we wanted to do was tax New Zealanders on their worldwide income. That's why we changed the rules back in 1988.
And is he not your lawyer anymore?
Well, it's just he's technically not a lawyer, but he provides the same services to me as he used to before.
In the IRD email to Mr Macleay when he was Revenue Minister, there's reference there to the fact that there could be a number of trusts which have set themselves up so they can't not register to defeat their statutory obligations, is the wording that's used. Yep. Now that number could, if you look at the various figures that have been tossed around, be as high as 12,000. Is it possible that lurking within the unregistered trusts who set up to defeat the statutory obligations, there are all sorts of things that could be going on?
I can't answer that question because I can't answer it until we can look at the papers and get a full understanding of what's gone on. But as I've said a few times in the last few weeks, it's really important to understand that the Panama Papers and the role of Mossack Fonseca goes back 40 years. And the problem is it predates a whole lot of changes that have happened in New Zealand law along the way. So when he talks about the Cook Islands, any reference to New Zealanders is prior to 1988. When he looks at shell companies that were established in New Zealand, our government actually closed those down. So there's been a lot of different changes that will inevitably have references, but they're out of date because we've actually effectively fixed that part of the law. And what we've always said in this process right from day one is we have been reviewed by the OECD, we've been reviewed by Transparency and others, and we rank at the highest level. But if there is a particular thing that emerges that our officials haven't considered or could be improved, then we're going to do that. In disclosure, that'll come out through John Shewan's work. In tax, it'll come out with the OECD work. But if there's some weird thing in there that we don't know about that needs to be addressed, we'll address it. But at this point, we haven't seen anything, but because we haven't seen all the information, we'll get a bit better handle of that on Tuesday.
It's clear that Ken Whitney has been in contact with Mossack Fonseca now. Did he mislead you?
No, I mean, he provided a reference, as I understand, because I haven't spoken about that now, I've just seen it, but he's provided a reference about a New Zealand law firm. Well, actually, if another company is asking for a reference, by definition, usually you think those people are pretty reputable, actually, because if they're not reputable, they don't care about it. So there's no issues. He is not, as I understand it, worked with Mossack Fonseca, but people ask for references, his references in relation to that individual. There's nothing wrong with that.
The sheer number of times that New Zealand has been mentioned now, does it have you concerned about a reputation as a tax haven?
Well, that's the real danger, that people, and with greatest respect in the media, sort of start saying that when it's fundamentally not true. I mean, even the AFR article yesterday says New Zealand's tiny compared to all these other jurisdictions. Actually, it's over 40 years. A lot of it's historic and therefore no longer in practice. And I mean, 40 years of any country's tax system being looked at changes a lot. So all I can say is that we take our reference point from those who can look absolutely at New Zealand, and those that look at us, like OECD, rank us the highest because we have 45 double tax agreements, we have information sharing agreements with dozens and dozens of other countries, well over 100 in total that we have either double tax agreements or information sharing. We have a 100% record of complying with information when any jurisdictions ask for it. So the fact that New Zealand gets mentioned, look, they may well mention some people on Tuesday, New Zealand law firms or New Zealand accounting firms. By definition, if they've mentioned, doesn't mean they've done something wrong. So you've got to put it in the context of a whole lot of things. We're part of just, a global world where, people, it's not illegal. In fact, it's quite legal, and it was established by the previous Labor government, disclosure rules around why a foreign trust can exist. There's nothing of itself that's wrong about that. And 2 members of the New Zealand Parliament have a foreign trust. There's nothing illegal in having a foreign trust. The issue is, and quite legitimate reasons why people have them, the issue is, of course, that you have to declare that foreign trust to the New Zealand authorities.
Mainly get named on Tuesday New Zealand time. Are you confident that there won't be any embarrassment for you or the National Party or the government?
Well, look, put it this way. I know my own financial position, so I'm not the slightest problem about that. Secondly, you can be pretty sure that, had I been on that list, you would have been talking about it a long time earlier than this, given they've had it for a year. So, look, in the end, we'll assess the situation when we see it, but the person's come out and said something which is completely and utterly wrong. It's basically claimed that I somehow have responsibility for the tax jurisdiction of the Cook Islands. As I said, as much responsibility as I do for Russia or Australia or the United States. I have no responsibility for that.
But will you be taking a close look at Cook Islands given the fact that you said we try and help them?
Well, we provide support to them to encourage them to have the best tax practice, and we do that in lots of ways. We send officials over there, but they negotiate their own agreements, they do their own things, and it's for them to make sure that they follow the best practice that we try and support them in doing. But I don't have responsibility for that. That's not my responsibility.
Can I ask a conference question?
Okay, one last one, then I've got to go. Sorry, but
Look, at the conference this morning, yet another remit on water.
Yeah.
Happened in Hamilton as well.
Yeah.
Are you concerned about the level of concern within the party about the iwi participation agreements?
Well, it's a legitimate question for people to ask about what does it all mean when there are potentially rights and interests for iwi when it comes to water. I think it's actually a complicated thing and it's difficult to explain because by definition some of it's actually not defined at the moment. But the most important thing for us is, and to our members would be that that the government's position is clear, which is there will be no national settlement. We believe no one owns water, and we believe any future allocation of water will be done on the basis of need, not and genuine commercial demand, not on the position of race. It doesn't mean that we don't and shouldn't recognise legitimate rights and interests, and we've done that with things like the Waikato River Authority. And sometimes people get a little bit confused, I think, in terms of what's actually happening. So, we'll just keep explaining that.